elect moot court competition, which is our general subject appellate moot court competition here at the National Law Center. This afternoon at 2 o'clock, the final round in the Giles Rich competition will be held, and that's intellectual property and patent issues. We encourage you to come back to that as well. I'd like to thank a number of people who have made some Herculean efforts to put this thing together, both in its initial stages back in the fall and later on. Peggy Bisping and Andrew Morgan back here standing up. Peggy is the chair of this competition, and Andrew Morgan is the vice president for interscholastic affairs with the moot court board, and they are the folks that are primarily responsible for putting this together. Mary Soltis over here on your left, raise your hand, Mary, is the one that wrote the problem for this competition. And if you ever want to have your writing scrutinized to the nines, write a moot court problem, and she can tell you all about it. Thank you, Mary. The competitors, people who competed in the fall to get here, but unfortunately didn't for them. But we appreciate their efforts. I'm sure many of you are out in the audience today. And our finalists today, thank you very much for all your hard work, and good luck to you. I'd like to mention our bench today. We have with us, we're very pleased to have today, the Chief Judge of the United States Court of Appeals for the Federal Circuit, Judge Edward Markey, Senior Circuit Judge Philip Nichols from the United States Court of Appeals for the D.C. Circuit. We're pleased to have Judge Ruth Ginsburg and Judge Spotswood Robinson. We were to have Judge Douglas Ginsburg with us today, as you'll see printed in your program. Unfortunately, Judge Ginsburg had to cancel at the last moment. I would refer you to the program for the fact pattern in this fictitious case and for other information about this competition. I'd like to introduce now Dean Jack Friedenthal, who has a few words and an award to present.
Well, thank you. I want to add my thanks to all the moot court and Todd, the people who participated. You know, you have to have people down here who are fighting to make the final round distill the best people out, and I'm told that we have some great people to argue. Of course, it's always important to have a good problem and someone who can create one. We always know that creation of litigation is an art that is very important to all of us. So I thank Mary. It's my pleasure to award the Jacob Burns Van Black Award to the winners of this competition last year. Jacob Burns, what can you say about a man whose name appears on most of the building? But he's a great man, a great supporter, and he provides an award, both a cash award and a medal. As I understand it, the important half of that, the cash award, has already been awarded, but the medals take a little more time. I would ask Denise Jennings and Stephen Horn to please come forward and receive those medals at this time. Sit back, relax, and enjoy what I'm sure is going to be a very interesting argument. Thank you.
Thank you, Dean Friedenthal. Well, we're going to get started. At this point, we're going to close off the doors in the back for the comfort of the competitors and the bench. If you feel you need to leave, please feel free to do so, but when you return, you'll be asked to wait until an appropriate breaking point in the competition so that you don't disturb anybody. With that, as the dean said, sit back, relax, enjoy. Good luck to our competitors.
All rise. Oyez, oyez. All those having business before this court, draw near and give your attention. This court is now in session. God save this court.
Morning, everyone. Court has read the briefs. We'd be glad to have counsel get as promptly as possible to the issues before us in each case. And the case this morning is the tribal government of the Potomac Indians versus John Z. Farmer. The court will hear first from Mr. Crampton. I got that right?
Mr. Chief Justice, and may it please the court, I would like to reserve rebuttal time.
Very well.
We represent the petitioner in this case, the tribal government of the Potomac Indians. I will address the free exercise clause issue, and my co-counsel will address the establishment clause issue. The petitioner asks this court to uphold the 13th Circuit's ruling that the government's proposed road building would violate free exercise, and to reverse the 13th Circuit's determination that the establishment clause would be violated by the granting of a special use permit. For centuries, the Potomac have conducted ceremonies in the Cocola National Forest, adjacent to their reservation. The most vital ceremony is the Great Vision Quest. The Potomac receive guidance from their deity, the Great Spirit, during this ceremony at Elk Mound. The respondents would build a roadway over Elk Mound, disrupting grave sites and cutting directly over a sacred site. The respondents
You, in your opening, referred to the long history of this religious practice. You emphasized that in your brief as well. And I was wondering whether you place any legal significance on the length of this practice. Would the argument be any different if this were a new but yet bona fide religion?
If it were a bona fide religion, it would be no different.
So you don't, the long history of this practice is irrelevant for our purposes?
The long history of the practice tends to show the bona fide nature of the beliefs.
Isn't that stipulated?
Yes, Your Honor.
It's stipulated that the belief is sincere and so on.
That's correct. The test in a case like this is that if the government places a burden on free exercise, it must bring forth a compelling justification, furthered by the least restrictive means. In the case last year of Ling, 3 principles were established for determining how to determine whether there's a cognizable burden under free exercise. The first principle in Ling is that the court in that case, was concerned because courts could not determine the truth of underlying beliefs of a religion. In this case, the respondents concede that the beliefs are sincere, so therefore there's no problem with the truth of the beliefs. Also, in the Hobby case...
Before you leave the Ling case, isn't the main point in the Ling case that the Indians had no property interest in the land that they were disputing about in the lawsuit?
It's true, Your Honor.
It was wholly owned by the government.
That's true, Your Honor.
That's equally true in this case, isn't it?
That's correct, Your Honor.
The boundaries of the reservation are entirely apart from the territory that's in dispute.
That's correct, Your Honor. But there are some vital distinctions between this case and the Ling case.
What are they?
Okay, Your Honor. The Ling case asked whether there was an indirect coercion or penalty on religion. In the Ling case, it seemed less than certain to this court that the government's action in that case would doom the religion. In the present case, these ceremonies are essential to the Potomac's existence as a tribal people. This case will result in the destruction of their religion.
Well, didn't Justice O'Connor concede that the road building project in the Ling case would be very destructive to the religious situation of the Indians that were the litigants in that case?
Yes, Your Honor, she did. However, she mentioned specifically that it would be destructive to certain ceremonies, but not destructive to the religion as a whole. Also, in the Ling case, the road the government proposed avoided as far as possible the sacred sites. The Native Americans in the Ling case were requesting an injunction over a large area of property when the road did not actually go over any sacred sites. In this case, the roadway passes directly over a site sacred to the Potawatomis religion, and furthermore, it cuts directly through a religious cemetery and necessitates the excavation of grave sites.
Is a Native American an Indian that's going to win a lawsuit?
Sorry, Your Honor?
I say, is a Native American an Indian that's going to win a lawsuit, and an Indian that's going to lose a lawsuit?
I believe the terms are interchangeable, Your Honor.
I noticed that in the Ling case, the prevailing opinion calls them Indians throughout, and the dissenting opinion calls them Native Americans.
Well, we hope in this case that they're Native Americans. The effect of the government's action in this case is to destroy the Potawatomis religion. This is prohibited by the Free Exercise Clause. This is akin to a law forbidding this worship. Now, to analogize, in the Hobby case, and in other cases like it, when an adherent claimed they could not observe their Sabbath because of certain restrictions placed because of indirect coercion or penalty upon them, that was considered an indirect coercion. In this case, the Potawatomi are not able to observe their most vital religious ceremony, the Great Vision Quest, because they believe the roadway will destroy the efficacy of that ceremony. And the respondents concede that these beliefs are sincere. The Ling case also mentioned that a coercion was related to whether an action caused adherents to act contrary to their beliefs. And as I just demonstrated, the Native Americans in this case would have to act contrary to their beliefs.
Crampton, if you line up the cases, you've made some very fine distinctions, including the efforts made to avoid conflict with the religion in Ling. But if you line them up and you take a realistic approach, isn't it the case that when it doesn't cost the government money or a lot of money, as in the Yoder case involving the Amish children or Amish children and their parents' religious belief that they shouldn't attend school after the 8th grade was respected, didn't cost the government a penny. In fact, it saved them money because they didn't have to provide public education for these children. But here, as in Ling, you are asking the government to pay out a lot of money that it wouldn't have to pay out otherwise, and isn't that the critical distinction if you line up all the cases?
Your Honor, respectfully, in Ling, the government had 3 alternative routes. However, each one of those routes would have violated sacred areas. So the Native Americans in that case, or the Indians as you like, were claiming an injunction over a rather large area, and the government had no alternative routes. That brings me to the next point. The government has brought no justification for its burden on the free exercise of religion. They have not used the least restrictive means. There are 3 routes in this case that avoid the sacred site, and according to Alfred Wegener's affidavit, the only consideration appears to be money. The affidavit considers the geological soundness of the different routes and correlates it with the cost to bring it up to a travelable road. So therefore, the government is simply trying to save 50% off of the cost of the cheapest alternative route at the expense of the Potawatomis' religious freedoms.
Could either of the alternative routes be made as safe as the one that has been chosen?
Well, Your Honor, the affidavit does not mention that. It seems that the tone of the affidavit would be that all of the roads will be in as good stead if the expenditures were made. The respondents make a contention that they want to use the road to transport hazardous waste, and that's their compelling interest. That was never raised in the lower court as a compelling interest. But even if it were, there's no evidence in the affidavit or any other evidence as to which route is safer. There are other factors involved in a road besides simply the length of the road and the cost to construct it.
Couldn't the court take judicial notice of all the environmental impact statements and of other material produced in connection with the decision to build this road?
Well, I don't believe the environmental impact statements considered the nuclear waste. It's not clear from the record.
Considerable government involvement in that too, in licensing the construction of a nuclear plant, isn't that so?
That's correct. Now, but the plant is licensed for future construction by the state, and the road was okayed for construction now through the forest, also for a route of commerce and to provide access to hunting and fishing sites in the forest. A further contention the respondents make is that the effect of our claim would be to provide the Potomac with a veto power over governmental actions. And that contention is unsound. Anytime a plaintiff brings the government into court, they're asking the government to take some action. In fact, in the history of this court, it has been that this court has the power to overturn legislation and government actions in order to uphold the Constitution. So this is not a case of exercising veto power, but rather it's the protection of a constitutional right.
What troubles me, frankly, is that the Indians seem to be asserting a kind of negative easement in the property in question, where, as you stated at the beginning, they have actually no property interest in it whatsoever.
That's true, Your Honor, but this is property owned by the federal government, which has the duty to hold the property for all of the people, and also the duty under the First Amendment to provide free exercise of religion to all the people.
You make a distinction according to who the owner is, whether it's the government or a private owner.
I think there's a potential for a distinction there.
So if it was Monsanto Chemical, that the rights would be greater.
Well, the First Amendment reads that Congress shall pass no law prohibiting free exercise. It's directed at the government and not at private individuals. In conclusion, the respondents would build a roadway that will effectively destroy the Potomac Indians' religion. However, there's no compelling justification in this case.
Are you telling us, I want to be clear on your position here, that we cannot take into account the health and safety of the rest of the people in the state, and the fact that the route that you would exclude is the shortest and safest way to get from the projected nuclear plant to the disposal area?
Respectfully, Your Honor, although that is a valid consideration, there's no evidence in the record other than the length of the road
Wouldn't
to...
we have to at least remand? That's a vital public, wouldn't you classify that as a vital public interest, the health and safety of all the people in the area?
That is a vital public interest, but in light of 3 roads which apparently can be brought up to equal passability, the government has not chosen the least restrictive means.
Would you agree that a remand would be the appropriate solution, because you wouldn't want to decide this case, would you, on the basis of an absence of material in the record, when that material might affect the health and safety of all the people in the state? So you would be arguing that that is something that should be fully fleshed out if it's not in the record now.
Well, Your Honor, I think it's premature now to consider that interest as a compelling justification, as the power plant has been merely approved for construction, and it generally takes years for a power plant to come into operation.
Now or never, if the road can't be built here, it has to be built someplace else that's less safe, and that requires transporting this waste a longer distance.
Your Honor, but if the respondents had shown that the longer distance and that the other roads were less safe, then they could show that it was the least restrictive means. However, in this case, there's no evidence of that. and-
If they could have showed it, they would have, and we can infer from the absence of the material in the record that the material would have been unfavorable to them.
That's correct, Your Honor.
Counsel, your time has expired, but we've asked you a lot of questions. The court will provide about 30 seconds and a minute if you want to summarize in a sentence or two your basic fundamental position.
Thank you, Your Honor. The respondents would build a roadway which will cause the destruction of the Potomachee's religion with no compelling justification. To protect the Potomachee's free exercise rights, this court must uphold the 13th Circuit's determination that the government's proposed road violates free exercise.
Thank you. We'll hear now from Mr. Osofsky.
Chief Justice, may it please the Court, I will address the Establishment Clause issue for the petitioner, the tribal government of the Potomache Indians. The Potomache tribe is camped in a remote area of the Cocola National Forest for centuries. The tribe was denied a permit now required by the Forest Service to camp in the forest for more than 5 days. The Forest Service routinely grants such permits to secular groups, but has denied a permit to the tribe because the Forest Service claims allowing the tribe to conduct its cultural and religious ceremonies in the national park violates the Establishment Clause. The Establishment Clause requires the government to act with neutrality between religion and non-religion, as well as between various religions. The Court of Appeals for the 13th Circuit incorrectly held that granting the special use permit violates the Establishment Clause by erroneously applying the Lemon test. This court must reverse the lower court because granting the permit is consistent with the Establishment Clause. In Lemon, this court enunciated a three-part test to guide a general inquiry in Establishment Clause cases. According to Lemon, governmental action only violates the Establishment Clause if the government's purpose, in this case for granting a permit, is to promote or disapprove of religion, the primary effect of granting the permit would inhibit or advance religion, or excessive governmental entanglement with religion would result. Now, the burden is on the tribe to show that granting the permit meets each part of the Lemon test, and the tribe meets this burden. I will first address the purpose prong. The lower court erroneously focused on the purpose of the tribe's activities. The court should have focused on the purpose of the government's activity, which is the act of granting or denying the permit. It's a subjective standard. We look at the government's motivations. In this case, the government's motivation is to implement neutral park regulations which enhance equal access for all groups.
If it's subjective, Mr. Rosowski, does that mean that the decision maker, the official, can be examined on the stand if it's a situation where it could have been for a permissible reason or for an impermissible reason? Then the only way this question can be resolved is to put Farmer on the stand and interrogate, to smoke out what is his real reason. Is that so?
Well, in past cases, there's usually been a law that's been passed, and there's legislative history to look at to determine the purpose behind the government's passing of a particular law, whose purpose was to promote or disapprove of religion.
So how do we apply a subjective test to the mind of Congress?
We look, well, one way is to evoke testimony. Other ways are looking at
All
the...
members of Congress, the majority leader to testify, the majority leader at the time if she's still alive?
Well, I'm not familiar with that way of doing it, but I would assume looking at the legislative history would be the best way, and that's how this court has looked at other purposes. I think it's clear in this case that there is a legitimate secular purpose in that promoting equal access to all groups is a purpose which does not violate the Establishment Clause. The permit merely allows the tribe to practice its faith on Mount Barren, where it has done so for centuries. The tribe provides all the funds and labor necessary to create the campsite, and the tribe won't exclude non-members from the area. Moreover, any reseeding and cleanup costs incurred by the government are no different from when any other group uses the forest. The permit is a public benefit available to all. It's routinely granted to scientific groups for a 3-month period, to mountain climbers. Religious groups will not benefit any greater than secular groups, rather they will benefit equally, because the permit is a public benefit available to all members of the community. I will now address the primary effect prong, which is an objective standard. We look at the tribe's activities to determine whether or not an objective observer would appear to them that the government is endorsing or creating a symbolic union between government and religion. There are 2 reasons why granting the permit does not violate the primary effect prong. The first reason is that granting the permit only benefits religion indirectly and is neutrally available to a broad class. And secondly, people using the park will not perceive a symbolic link between religion and government or perceive the government is endorsing religion.
I don't follow your characterization of the effect on the religion as indirect. This is a permit to carry on for every day of a 3-month period a religious exercise. How can that be characterized as an indirect impact on religion?
Well, I'm characterizing the benefit as general governmental services available to all, such as if the permit itself is granted to all groups, it's available to a broad class.
So you can see that this can be allocated on a first-come, first-served basis.
As long as there are neutral regulations governing, then it should be, that is a perfectly neutral way of...
The word indirect and remote out of case law, I appreciate that, but it is, in a common sense way, a little difficult to think of a religious exercise. That's what they're doing. Every one of them, they're not having relay races. They're engaging in their most sacred religious ceremonies.
But the focus when you look at it in that way is on what exactly the government is providing to this group. Is the government acting to endorse or promote or put its stamp of approval on religion? And all it's really doing in this case is providing general governmental services to the tribe. The permit available to all groups, the cleanup and reseeding or the police protection, those types of services are available to churches and synagogues which promote religion. The sanitation, police protection, fire protection, those are general governmental services. They indirectly help, as opposed to direct, which would be money aid.
You have a point that the government could never be supposed to be intending to assist the Indians to make converts to their religion among the general public.
I don't follow. Could you please rephrase the question?
Could it be supposed that the government, by permitting this activity of the Indians on government park, is assisting the Indians or making their religion an official religion of the United States?
Well, that's where the facts are so important in this case. We look at such things as the location of this activity. In this case, it's occurring in a park. A park's land is from ancient times, been available for all groups without discrimination. We look at the audience. We look at the types of activities they'll be engaging in. Such things as they were recruiting adherents or putting up crosses or other independently significant religious symbols that would appear that the government is endorsing religion. Those things aren't occurring. There's a historical issue in this case, which I think the court has looked at in Marsh versus Chambers. History is an important thing that they consider.
So you disagree with your colleague that it doesn't matter whether this is an old practice or a new practice. He said as long as it was a bona fide religious practice, it didn't matter whether it came from a new religion or an old religion.
No, I agree with him as with the what history relates to the free exercise clause. With regard to the free exercise clause, the sincerity of the belief is what is important, not how long they've believed. Someone could believe in a new religion in a day. But what's important in this case,
That religion might have a 3-month worship session on parklands. The new religion might have that as well.
exactly. But what we're looking at in this particular, the effect prong, is what it will appear to an objective observer. And the fact that there's road markers and commercial establishments that would signify to anyone walking in the forest that this has been going on for a long time, we won't have that perception by the public that the mere granting of this permit is what is endorsing religion. That's why history is so important in this case. And that's how the explanatory signs help the objective observer. So those factors all demonstrate that people using the park will not perceive a symbolic link between religion and government.
You're making then a distinction between religions that are simply practicing in the closed circle of the practitioners and those that might be trying to attract outsiders. In other words, between religions that proselytize and those that don't seek converts. Is that so?
Well, I'm making that distinction in the sense that when the court has held parochial schools to be pervasively sectarian, they've looked at certain factors that make it pervasively sectarian. And one of those factors is it's focused on recruiting or indoctrinating youngsters who are, in those cases, a captive. They're captive in a classroom. They're young and highly impressionable, and they're subject to a high likelihood of coercion. But in this case, it's taking place in a park where people can come and go. Parkland has this significance of for free speech, where people there's not that captive or coercion problem that one would find in a parochial school. And that leads into my next point as to why there's no entanglement. Because this court has only struck down cases on entanglement grounds which involved aid that went to parochial schools because they were found to be pervasively sectarian. And this court has only characterized parochial schools as pervasively sectarian.
Would it be permissible if we had an avowed proselytizing sect to say, no, you can't use these parklands because you are trying to attract outsiders? Would that be permissible?
That would be permissible if it doesn't, see, there's the reverse establishment clause problem. You see, once we meet the test of showing that we meet all three elements, the burden goes on the government to show that denying the permit does not violate the establishment clause. Now, if the tribe was to if the Forest Service was to implement regulations which were to single out a religious group because of certain reasons that only religious groups would have, their purpose there would be to disapprove of religion, which would violate the establishment clause, and its potential.
I'm just giving you the simple proposition that if attracting the public to a religious worship is important, then the line ought to be between religions that don't want any outsiders and religions that do want to attract converts, do want to make converts.
Well, Your Honor, the point I was...
We have an administrator to decide case by case which the religion fits.
Well, Your Honor, I think that the regulations should be neutral, but I agree that it should be decided on a case-by-case basis.
How about my regulation? Religions that don't recruit can camp and perform their religious ceremonies here. Religions that seek converts can't. That's my regulation. Would that be permissible?
It may not be, depending on whether or not your purpose in putting that particular regulation in place is to disapprove of certain religions.
So again, we have to examine the decision maker, the head of the department responsible.
Well, that's the one thing we'd have to establish, we'd have to look into. But the other thing we'd have to look into is whether or not that particular regulation that you referred to, whether it had the effect of inhibiting or disapproving of a particular religion. And that burden would be on the government in that case. I'd also like to state that the respondent cited political divisiveness as a significant factor in measuring entanglement. In this court's most recent Supreme Court case, Bowen versus Kendrick, the court said the question of political divisiveness should be regarded as confined to cases where direct financial subsidies are paid to parochial schools or to teachers in parochial schools. In conclusion, this court has consistently said that governmental neutrality toward religion is the preeminent goal of the First Amendment. Granting of the tribe a special use permit is consistent with the neutrality principle because the permit is available to all other segments of the community. In light of the historical use by the tribe and the region's significance to the area, to the tribe, this court must reverse the lower court's Establishment Clause ruling because granting the permit is consistent with the Establishment Clause. Thank you.
Thank you, Mr. Rotowski. I'll hear from Ms. Dankner.
May it please the court. My name is Renee Dankner. I am representing the respondent, John Z. Farmer, and I will be addressing the Free Exercise Clause issue. My co-counsel, Ms. Sobel, will be addressing the Establishment Clause issue. Your Honors, respondent will show the construction of the roadway does not unjustifiably infringe upon the petitioner's free exercise rights. The respondent will show that the petitioner has not properly demonstrated that a cognizable burden on the free exercise of religion exists.
Excuse me, counsel. Is the argument that it does not unjustifiably impinge? Assume that it does impinge. There's no argument about that here, is there?
Well, Your Honor, the respondent respectfully submits that any burden that might occur from the construction of the roadway is merely incidental, and that the construction of the roadway is isolated to the northeastern portion of the sacred site.
That's one way of characterizing the impingement, but my question was whether, when you say justifiably, that it's an assumption or an acceptance or a concession that there is, in fact, injury here.
Your Honor, respondent is not conceding that petitioner has successfully demonstrated that a cognizable burden does exist. However,
How does the petitioner have to demonstrate beyond that the Great Spirit, the central force of this religion, resides at the very place where this road is being built, so that you are literally going over, trampling on the heart and mind of the deity? What could be more direct and devastating than that? Why are you resisting that concession? How can you possibly say that there is not a severe burden on the religion in this case?
Your Honor, the First Amendment protects individuals against government action which prohibits their free exercise of religion. And respondent is asserting that the construction of the roadway does not prohibit their free exercise of religion. Although it may make practice of the Great Vision Quest somewhat more difficult, the construction of the roadway will not prevent the petitioners from performing the Great Vision Quest.
Do I misunderstand the record on the point that the Great Spirit in fact resides at this place where the road building is scheduled to occur?
Your Honor, the petitioners do believe that the Great Spirit has selected Elk Mound as its final resting ground. However, the record does also reflect, and also the affidavit of Ms. Healing Woman reflects, that the importance of Elk Mound is that the Vision Quest occur there because it is the place of origin of the Great Spirit and the site where the Great Spirit first appeared to the petitioners, and it is for that reason that it's important that Elk Mound be used as the site of the Great Vision Quest. Furthermore, the respondent is not restricting the access of the sacred site of Elk Mound. Petitioners will still be able to congregate, and there is ample room for the petitioners to congregate. The record clearly reflects that the Great Vision Quest primarily takes place at the base of Mount Barron, located in the foothills of that region, and that is located on the westernmost portion of the sacred site of Elk Mound. The roadway is scheduled to be built on the northeastern upfractional portion of the northeastern segment of the sacred site, and therefore there's ample room for them to congregate, and the respondents don't intend to deny access so that they could still perform their sacred ceremony. And so in that sense, the roadway does not prohibit them from their free exercise of religion, which is what Justice O'Connor, in this court's recent decision in Ling, stated that the plain language of the First Amendment requires in order to find that a cognizable burden does exist.
Well, excuse me, if it wasn't in Ling, all they were going to do is pave a dirt portion of a pre-existing road. The road's already there. Isn't that true in Ling?
Yes, Your Honor.
And weren't the petitioners there looking for protection of some 17,000 acres, something of that sort? So they're not factually identical here, it seems to me, and particularly in the light of Judge Ginfer's question. I, too, am impressed with, you may be biting off more than you can chew. It's too early to say, but to say there's no impingement here or an inconsequential or inferential or a put-down of the injury to the free exercise clause, or to the free exercise right, seems to be a bit much. But we're clear, I guess, that you are maintaining that.
Well, Your Honor, even if this court were to find that such a burden did in fact exist, the respondent maintains that in any case it would be clearly outweighed by compelling governmental interests and public safety, and that the proposed roadway is the least restrictive alternative. And those are the second and third prongs of the First Amendment test, and that's what free exercise jurisprudence requires. There's a compelling government interest in the safe transportation of volatile hazardous nuclear waste. The Ritsu River plant is scheduled to begin construction on March 23rd of this year. The roadway would primarily be used for the transportation of hazardous nuclear waste from that plant to carefully chosen designated waste disposal sites. These sites have been carefully chosen, and not all land can accommodate them, so for that reason, they are south of the city of Valdez, which is in the southernmost region of the state of Burns, Dakota. The nuclear power plant is located in the northernmost region, and therefore, a direct roadway which would accommodate the safe and efficient transportation of such hazardous nuclear waste is of vital interest to the respondents.
Is there any Supreme Court case authority that supports your position?
There is no, to the best of my knowledge, there is no Supreme Court case on point which shows that a roadway would be of vital interest. However, there are cases which state that the interest in public safety is paramount. And in this instance, where there could be a threat of nuclear catastrophe, if a roadway were not safe enough to accommodate such hazardous nuclear waste, which could indeed possibly endanger and threaten and annihilate the entire citizenry of the state of Burns, Dakota, including the petitioners which reside in that state, that is a great and of compelling interest to the government.
Your opponent laid great stress on the distinctions that they pointed out with the Ling case, but you don't seem to be putting any reliance on it.
Well, Your Honor, while in the Ling case, the government was able to accommodate the petitioners because it did involve the larger tract of land, the petitioners in that case did claim that all of the land was religiously significant to them, and that the roadway traversing through any of the land desecrated the land and therefore destroyed the spiritual character of that land. Furthermore, the majority opinion in that case said that even if the roadway would virtually destroy the practice of their religion, that petitioners in that case had still not demonstrated a cognizable burden. And unfortunately, in this case, petitioners are claiming that all of the sacred area of Elk Mound is sacred to them, and that similarly, that any presence of any roadway would desecrate the land.
Isn't there a considerable difference in the size? You said stress all, but here all is 500 acres. What was all in the Ling case?
Your Honor, in the Ling case, it was a significantly greater tract of land, and unfortunately that distinguishes the case. However, in this case, unfortunately, we're not able to provide similar accommodations because this roadway, the proposed roadway, is the most direct and efficient route. Although other alternatives do exist which completely circumvent this route, the other alternatives...
Different case, say, if it were 10 acres instead of 500.
No, Your Honor, because in this case, the roadway is necessary and vital to the safe and efficient transportation of hazardous nuclear waste. And unfortunately, however much we would wish it were otherwise, that we could be able to accommodate them, the First Amendment doesn't allow petitioners to dictate the internal procedures of the government, and the government has an interest in developing and managing its own land. The sacred site of Elk Mound is located within a national park, and although the government's property interest isn't determinative on this issue, it is indeed a factor which must be taken into account in weighing the relative interests of the parties.
In your brief, in your brief and this morning, you've referred to the government's planned road as the least restrictive alternative. And my question comes on restrictive of what? Of petitioners' free exercise rights? Is that what you mean by least restrictive?
Your Honor, unfortunately, given the alternatives that are available to us, this would have to be the least restrictive alternative because it is the only means by which the government can accomplish this compelling interest. Although,
It's the most restrictive of petitioners' rights, isn't it?
Your Honor, while this particular roadway is the most restrictive of petitioners' rights, it's the least restrictive alternative available to the government in this case.
Well, why is it, what in the record forecloses the promotion of safety equally well if enough money is spent on one or the other of the alternatives?
Your Honor, the other roadways involve significantly higher sums. The next least expensive involving $61.6 million.
There isn't anything in the record to suggest that it is impossible to make one of the alternatives just as safe. Is there?
No, Your Honor. The affidavit does suggest that the initial construction could be made just as safe. However, the affidavits do clearly reflect that there would be increased maintenance costs associated with the alternative roadways. And the government's primary concern so far as the increased maintenance costs are...
Seems to be money.
No, Your Honor, the respondent's primary concern is with with safety, and that because of increased maintenance costs...
You just said that it could be made just as safe. It was a question of how much it would cost to maintain it. There were how many alternatives that were considered? How many other routes?
Your Honor, there were 3 alternative routes considered.
Every one of those routes longer?
2 of the routes were longer alternatives, 2 and 3.
And one of them was shorter, or the same?
One of them didn't have a significant linear mileage difference. However, that was alternative 1, which was plagued by loose soil compaction and an elevated water table. And if I might return to the respondent's primary concern with the increased maintenance costs, is that the maintenance repairs cannot occur immediately, and that there will be various portions of these alternative roadways due to the fact that they don't have the natural geological soundness that will be in state of disrepair, and that they would then pose significantly higher risks, increased potholes or cracks in a roadway which could not be taken care of immediately, which in light of the compelling interest in the safe transportation of hazardous nuclear waste along this roadway poses a danger that is just too much to ask the citizens of Burns, Dakota to bear. And it is that reason why the maintenance costs are so important. Furthermore, the additional linear mileage suggests that the hazardous nuclear waste would be carried along the roadway for a longer period of time. And in that sense, the government has a supreme interest in the quickest, most efficient transportation of hazardous nuclear waste so that it can be disposed as safely as possible at the carefully chosen designated waste sites.
So you've modified your answer and you said it's not just money now. I take it from what you said that the safety concern is carrying this waste over a longer distance and the inability to repair the road on the spot so that there will be periods of time when the alternative route would be substantially more hazardous.
Yes, Your Honor, that is respondent's primary contention insofar as why this proposed roadway is the least restrictive alternative in light of the paramount interest in public safety of the citizenry of Burns, Dakota.
How far?
Excuse me, Your Honor, how far?
No, what I'm trying to find out is when you make comparisons, of course, there may be differences. How great is the difference in this case?
Your Honor, any increased significant
Well,
threat.
let's talk about the longer exposure of waste on the route. What are we talking about? We talk about 24 hours, or are we talking about 20 minutes?
Your Honor, in this case, one roadway is 35 additional miles and the other roadway is 40 additional miles. However, both of those roadways also have less geological soundness associated with them. So in addition to there being more linear mileage, there is more area on the roadway that could be exposed to the devastating and destructive climatic conditions. And being that there is not the natural geological
Well, I
soundness.
think that all routes will be subject in some degree, will they not?
Yes, Your Honor, that is correct. However, the proposed alternative is the most geologically sound and would require the least maintenance, and therefore just extrapolating from the figures alone would indicate that there is less of a risk that, or less of a chance that there would be more roadway infirmities along that route.
Well,
In response to that, excuse me.
you've spoken about distance. Now, does the record reflect anything as to in what degree there will be differences between these routes insofar as maintenance is concerned?
Your Honor, the record reflects, in the affidavit of Alfred Wegner, the record reflects the increased maintenance costs. And respondent...
Well, speaking about costs, really I'm concerned about such things as the potholes that you mentioned.
Well, Your Honor, the affidavit does clearly reflect that various portions of the alternative routes would be vulnerable to destructive climatic conditions.
They're all going to be vulnerable to potholes, aren't they?
Yes, Your Honor. However, the proposed alternative...
Some perhaps more than one or the other of the remainder. But how much are we talking about? I mean, is it a great deal, or is it just a small amount? I'm not speaking about money.
Well, Your Honor, in light of the fact that the proposed alternative has significantly greater soil stability, Alfred Wegner seemed to be confident in the fact that it would be the most durable roadway. And in fact, in his affidavit, he stated as such. Therefore, asking the government, when only an incidental burden would occur, to accomplish their compelling interest by spending significantly larger sums of money only to build then significantly lesser safe roadways, it does not seem to be in accordance with the mandate of the Free Exercise Clause, which says that the individual is protected from government action which prohibits their free exercise of religion. And in this case, the respondent is maintaining that although the roadway may make the performance of the Great Vision Quest somewhat more difficult, it is not prohibiting them from their free exercise of religion. And that is a burden that the petitioners must come forth with even before we get to the question.
How could they ever meet it, on your terms, how could they ever meet it? They've said this is the heart of our religious practice. And let's assume the case that I put, if there's any doubt about it in this record, the Great Spirit resides at this very spot. If that is the case, so there isn't any question of the devastating impact on the religion, must the government back off and choose one of those less desirable routes?
Your Honor, in this case, according to the coercion analysis as this court articulated in Ling, in order for the petitioners to show a cognizable burden under the coercion analysis, the government would have to restrict their access to the site so that they could not perform the sacred ceremony, or the roadway would perhaps, rather than being contained to the north or eastern portion, on a fractional portion of the sacred site of Elk Mound, be a multi-lane freeway running directly through, possibly cutting through horizontally, so that any effective access would be effectively denied. In this case, the roadway is isolated to the northeast portion of the sacred site. The petitioners are not being denied access whatsoever. They can still freely perform the Great
Take
Vision.
from what you said that there is an obligation, a requirement, that the government change its behavior in response to this religion to some extent. Is that you're pointing out that they could, it's in a small portion and they adjusted this or that. So you're conceding that the government must adjust, and the only question is how much. Is that right?
Well, Your Honor, the government has made all attempts that it could to accommodate the petitioners in this case.
Is the government required to do that?
The government is only required, no, Your
Is the
Honor.
government
How about
required
rain?
to accommodate?
According to the free exercise of religion, the government should consider the free exercise interests of all individuals. However, in this case, the government is not required to accommodate the petitioners any further than the government
Is it
already
required to
has.
accommodate them at all?
In this case, no further than it already has.
Well, what about Ling? It's the government's land. Can't the government do what it pleases
Your Honor, in
with
the,
its own land?
excuse me?
Can't the government do what it pleases with its own land, notwithstanding the impact?
Well, Your Honor, the government has an
How
interest
do you
in...
read Ling in that respect?
In the Ling case, it was important that it was government land.
Not so much on the facts of the case, but on the basis of what the majority opinion says. It's the government's land. The government owns the land. It can do what it pleases.
Well, no, in the Ling case...
Am I to read that for what it seems to say?
Well, respondent asserts that the Ling case said more than it was just the government land. In the Ling case, this court went through an entire free exercise clause analysis. So the fact that it was
You don't
merely...
want us to read the Lynn case in the light most favorable to your client, that's what you're telling us.
No, of course, I want you to read the Ling case in the light most favorable to my
Mustn't your
client.
answer be yes, it's the government's land and can do what it wants? Isn't that reading Ling in the light most favorable to your client?
In addition to it being the government's land and that we could do what we wanted, in the Ling case, the petitioners also did not demonstrate a burden, so that the government also had that on their side. Your Honors, I see that my time has
After your
run.
time has expired, you a moment ago did summarize your entire argument just before the last couple of questions, so we'll now hear from your colleague,
Thank you.
Sobel. Please proceed.
May it please the Court. My name is Lauren Sobel. I'm counsel for the respondent, John Z. Farmer. Today I will show the decision by the Forest Service to grant the special use permit that sanctions tribal worship and the performance of religious ceremonies in the midst of a national park is an establishment of religion in violation of the First Amendment of our Constitution. The respondent will show today that the decision by the Forest Service to grant the permit is incompatible with the Establishment Clause mandate of government neutrality toward religion, and that the decision by the Forest Service impermissibly burdens the Establishment Clause as measured by the three-pronged test laid down by this Court in Lemon v. Kurtzman. Respondent will show today that the primary purpose behind the permit will be religious, and that any avowed secular purposes associated with the permit are remote and incidental. Respondent will also show today that the decision to grant the permit has the primary effect of advancing religion, and respondent will also show that the decision to grant the permit will foster excessive entanglement between government and religion. While any one of these three would be sufficient grounds for this Court to find that the Establishment Clause has been violated, the presence of all three require this Court to affirm the judgment of the 13th Circuit and deny issuance of the permit.
Is it true, counsel, that the Potawatomi Indian tribe have been conducting this very same ceremonies in the very same area for 50 years or 100 years, whatever?
Yes, Your Honor. It is true that the
Now,
Indian...
excuse me. Agree that part of the problem in this entire jurisprudence is perception, whether or not the government will be perceived as favoring a religion or favoring religion.
That is certainly one of the primary concerns inherent in the Establishment
Apparently,
Clause.
For 100 years, nobody seems concerned that this camping activity is on government land, is somehow reflecting a favoritism to the religion.
In the
Now,
past...
is there anything in the record indicating that people know that they're now doing it under a permit where they weren't before?
Well, Your Honor, the Forest Service has implemented these regulations to issue permits for anyone wishing to camp in the forest for more than 5 days.
They anticipate more tourism and
That's
so on.
correct.
But I'm not making myself clear, perhaps. To the extent that we're talking about perception, why would the public perception change when on Saturday been camping for 100 years, there's no problem. Monday, because the government is issuing permits now, which the general public doesn't know about,
The public perception...
suddenly it becomes favoritism.
The public perception changes, Your Honor, because the public perception has changed, Your Honor, because, in fact, the public is aware, or could be aware, that such permits are being issued. And at this time, the government would be endorsing religion by granting such a permit for the tribe to practice their inherently religious activities.
I don't follow your meaning here. It is a fact that this religion doesn't want to attract a single convert. It's not interested in having any approval from any authority. It's just a religion that maintains itself with a small, close-knit group of adherents. So how could we be talking at all about promoting the religion when the religion doesn't want to, and has made it clear that it doesn't want to spread itself any wider?
Your Honor, the Establishment Clause in our Constitution makes no distinction between religions that recruit people and religions that just seek to perpetuate their own religious mission. In fact, the Potawatomi people do have a religious mission and are a pervasively sectarian group. Their religious mission is one to perpetuate their faith within their own people, and the dangers inherent in a government endorsing the worshiping in the national forest are certainly prevalent in this case.
So the government can't get involved with a religion that wants to establish only itself, doesn't want to become an official anything to any other person or group?
The clear mandate of the First Amendment is that government should remain scrupulously neutral in matters of religious conscience wherever possible. And in this case, the government's decision to not issue the permit would in fact enhance that, would in fact promote the Establishment Clause mandate of government neutrality. While
how is it neutral to say that because we allow anybody to use this park on first come, first served basis, but we're going to exclude you because you are a religious group? Isn't that not those philosophers, but if you are followers of this religion and you want to talk about the Great Spirit and Vision Quest, you can't?
the inherently religious nature of the tribe and the ceremonies that they wish to conduct associated with this permit distinguish them from any secular groups that would wish to use the forest and would receive access from the government by virtue of these regulations. Although the regulations are issued on a first-come, first-served to entirely secular groups, anytime the Forest Service were to issue such a permit to religious groups, there would be a promotion of religion by the government endorsing the activities and the religious ceremonies that would take place in the National Forest.
There was a mass held on the mall, and the Pope appeared. It seems to me from everything you said that was inappropriate or unconstitutional.
Well, Your Honor, the D.C. Circuit did find in O'Hare versus Andrus that the papal mass was not an establishment of religion, and the granting of the permit was not an establishment of religion. However, the D.C. Circuit case is not binding upon this court, and is also readily...
And I think you must say that because, after all, that it's a much larger religion. It does seek converts.
Absolutely.
And it was at a place where lots of people would take notice. So the cases are not distinguishable. In other words, if that D.C. Circuit was right, that it was okay to have a papal mass.
Well, Your Honor, I don't. Respondent does not contend that the D.C. Circuit was correct in the O'Hare that the Supreme Court today should follow the O'Hare case, because the O'Hare case is readily distinguishable from the case this court faces today. In O'Hare, the papal mass was being performed on the National Mall, and there were 500,000 people approximately that were attending that papal mass. Certainly all of them were not there for religious purposes. The entire tribe wishes to come into the National Forest and for 3 months practice their religious ceremonies in the forest. And for 3 months they wish to raise one voice as one people to revere their Great Spirit.
But they're not doing it in isolation. I thought one of the facts in the record was they're good for the locality because people come and watch these strange ceremonies and then go to the souvenir shops and the ice cream parlors. So I think there's a comparison to the mall there in those terms.
Well, the secular purpose that the petitioner has asserted in this case is merely incidental to their primary motivation, which is to practice their religion, and the government's...
Are we looking at the group? If we look at the group, their purpose will always be religious. If we look on the government side, isn't the government saying, we're just being neutral? We give out this parkland on a first-come, first-served basis.
Well, the government activity here is in fact going to endorse religion because the government activity is, the government's action here is
So to avoid endorsing religion, the government must be hostile to it, is that?
not hostile, Your Honor.
Must treat it disadvantageously vis-a-vis other groups that want to use this same land.
In order to promote equal access, the government in fact should deny the permit to any religious group that comes forward wishing to use the national park, because religious grounds for the government decision to issue the permit would actually further and promote and sponsor religious activity and have the effect, the primary effect of advancing religion, which is impermissible under the second prong of the Lemon analysis.
There was once a great tent city in District of Columbia, and there were several religious leaders involved in that. One of them was Martin Luther King. Was that a violation of the Establishment Clause to allow that minister to come on government parkland and preach a sermon?
No, Your Honor. In that case, the primary motivation behind Reverend King's desire to be in the national park was not the perpetuation of a religious mission, a distinctly religious mission. While that may have been an incidental effect, that was not the primary motivation.
Suppose he were to testify that he thought he was performing his God-given mission.
Well, the government activity, which is the decision to issue such a permit, would not have been, would have to look at the primary motivation of that group, and the primary motivation of Reverend King in that case would probably be determined a religious mission. However, in this case, the religious mission is clear. The tribe has readily admitted that they will conduct their most sacred religious ceremony in the national park, in which they will raise one voice and revere the Great Spirit. In addition, they wish to conduct other distinctly religious ceremonies in the national park, and this will, and if the government grants the permit, the primary motivation of the government's decision can be gleaned to be one that promotes religion and advances religion.
You've spoken consistently of groups and ceremonies. Suppose the government owns a beach, but it requires a permit to use the beach. And one person shows up and says, I want to fish. Okay, enter. Another one shows up and says, I want to swim. Well, that's fine, enter. But the third one says, I want to pray.
Your Honor.
What's the indicated response of the government in a situation of that sort?
Well, Your Honor, there is an inherent tension in the First Amendment between the Free Exercise Clause and the Establishment Clause. And while the government is